Hello, everyone, and welcome to the 2025 Hot Topics in Environmental Law Summer Lecture Series. I'm Christophe Courchain, the Interim Director of the Environmental Law Center and the Director of the Environmental Advocacy Clinic here at Vermont Law and Graduate School. We are thrilled to welcome you to the series this summer, which runs weekly through July. Each talk in this series is worth one Vermont CLE credit. So please keep track of which talks you attend for your records. We'll have time for Q&A after today's presentation. For those of you watching on VLGS YouTube, you may enter your questions in the chat space at any time, and we'll get through as many as we can. That's on the right-hand side of your screen if you're in YouTube. Today, we could not be more pleased to welcome Marianne Engelman-Lado. Marianne's career has been devoted to civil rights and environmental justice. She is currently serving as director of a new environmental justice lab at New York University School of Law. During the Biden administration, she served in both the Office of General Counsel and the Office of Environmental Justice and External Civil Rights at the Environmental Protection Agency, where she focused on equity, environmental justice, and civil rights enforcement, and carrying out the agency's mission to protect public health and the environment. She previously directed the Environmental Justice Clinic right here at Vermont Law and Graduate School, so we're thrilled to have her back. And she served as a lecturer at both the Yale University School of Public Health and the Yale School of the Environment, where she supervised interdisciplinary teams of law, environmental, and public health students working on environmental justice issues. She has served as a senior staff attorney at Earth Justice, where she focused on civil rights enforcement, as well as related issues in the areas of toxics, waste, and agriculture, and the effects of contamination on environmentally overburdened populations. Her experience also includes 10 years as general counsel at New York Lawyers for the Public Interest, a nonprofit civil rights law firm where she directed a legal and advocacy program addressing racial and ethnic disparities in access to health care, environmental justice, and disability rights. And she began her legal career as a staff attorney at the NAACP Legal Defense and Educational Fund, where she represented clients attempting to break down barriers of access to health care and quality education. Marianne has both lectured and published widely. She holds a BA in government from Cornell University, a JD from the University of California at Berkeley, and an MA in politics from Princeton University. We are delighted that she is here with us as a distinguished environmental law scholar at Vermont Law and Graduate School for this 2-week period. Delighted to host her for that. And today, for our Hot Topics lecture series, she will present Advancing Environmental Justice in a Chaotic Time. Oh boy, is it ever. Please join me in welcoming Marianne Engelman-Lado.
Thanks so much, Christophe, and thanks to Brian for working the logistics for us. And it's such an honor, and I'm so excited to be back at Vermont Law and Graduate School. I really appreciate everyone for inviting me and for the warm welcome. Next slide. So we're at a pivot point in the history of environmental justice. The EJ movement absolutely came of age, and now we're seeing a tremendous pushback at the federal level. We have to grapple with where we are and what it means for the future. We have to advance environmental justice. There's not a question about that. It is fundamentally about ensuring that all people have access to clean water, clean air, and a safe place for their children to play. And also it's about having a say in the future of people's health and environment. So the question is, how do we advance environmental justice in this chaotic time? I'm going to start with some level setting and then talk about where we were as of 11:59 on January 20th, when I left the administration and it changed, Inauguration Day. I'll then touch on the challenges posed by both the legal landscape and even pre-Trump, and now by the Trump administration, as well as possible pathways forward. Notably, we don't have to do too much speculation about the Trump administration because they've already taken a wrecking ball to environmental justice initiatives. I hope, though, to end on a positive note, because environmental justice did not start at the federal level, and it won't end with the administration's wrecking ball. Communities have driven the movement, and communities will continue to fight for environmental justice. Next slide. I want to say just a few words about my perspective. As Christoph said, I'm a civil rights lawyer who gradually focused more and more of my work on the environmental and climate and environmental justice sectors. I started my career at the NAACP Legal Defense Fund during what we might call as the dawn of the formal environmental justice movement, and increasingly spent time working on discrimination in the environmental sector. I started focusing on health and education, but realized that there was so much attention needed to civil rights enforcement and the enforcement of other laws in the environmental sector. So I started working on confined animal feeding operations, the location of medical waste incinerators, and other issues. There was simply a lack of civil rights enforcement in the sector, and over time, that is something that I've tried to address. Since the 1980s, the nation has learned what residents of environmentally overburdened and underserved communities have known for years based on their experience. In this country, the color of a person's skin and their income, but the color of a person's skin is a predictor, often the most salient predictor, of whether you're living near a polluting source and whether you're exposed to more pollution, such as particulate matter 2.5, the little pieces in the air that can get into your lungs. The release of the report, Toxic and Race in 1987, was a seminal moment in the birth of the EJ movement. Next slide. The report found a significant relationship between the race of a community and the location of hazardous waste sites, and indeed that race had more explanatory power than other factors such as income. In Dumping in Dixie, a book I recommend, Dr. Bob Bullard said that environmental racism, which was the term we used at the time, is the distribution of environmental burdens and benefits along racial lines, such that one racial or ethnic group shoulders a disproportionate share of the costs and another a disproportionate share of the burdens. We have a broader view of the idea of environmental justice, which I actually think was packed into what Dr. Bullard was saying. And we'll talk about that in a moment. Next slide. The findings of toxic waste and race have been replicated many times since the report was released in different contexts. Research has found relationships between the placement of multiple types of polluting sources and race, the availability of environmental goods such as trees and race and class, and exposure to particular pollutants. This is not a surprise given the history of land use in this country. The United States developed a land use policy and zoning layered on policies and practices of segregation and redlining. The vestiges of these policies have never been uprooted, unlike in the areas of education, for example, where the promise of equal education remains illusory. The Supreme Court in 1971, in a case that many of those on the phone probably studied in constitutional law, in Swan versus Charlotte Mecklenburg County, held that school authorities had the obligation to eliminate from the public schools all vestiges of state-imposed segregation. To the contrary, or in contrast, segregatory patterns of land use were never uprooted. If, for example, areas where communities of color resided were deemed industrial and polluting facilities were clustered nearby, there was no moment, no Supreme Court case that demanded that zoning laws be redrawn to address racial inequality. As a result, today, race, color, and national origin, a person's racial or ethnic background, is a predictor of exposure to pollutants. The visual image here is a map of New York City drawn by the Homeowners Loan Corporation. You can find these maps online for any city that's 40,000 or more. And this map guided access to mortgages and loans from the 1930s to as late as the 1960s. New York City, the association between redlining and current land use is a little attenuated because some areas have experienced gentrification or in and out migration, but not all. And as you may know, neighborhoods deemed hazardous in part on the basis, and I hesitate to say this, I don't want people to get upset, but on the basis of the fact that people of color lived in them. And those were shaded red on maps, and banks were discouraged from lending in those areas because they were considered high risks. So there are many other ways in which discrimination perpetuates and racial inequality in land use is perpetuated. Just to use an example, I live in New York, and in 1989, the Supreme Court ruled unanimously that the New York City Board of Estimates, which made land use decisions in the city, was unconstitutional on the ground that it violated one man, one vote. The city's most populous borough of Brooklyn had the same representation as the least populous, Staten Island. But unlike in the area of education, there was no requirement to root out inequality, root and branch. There are a lot of excellent resources happy to share with you. Next slide. A recent body of literature on the relationship between redlining and neighborhood environments, including, for example, exposure to 2.5 and other health outcomes, is reinforced. On this slide, there was a 2022 meta study looking at 17 such studies and reported that overall studies nearly universally report evidence of an association between redlining and health relevant outcomes. We see the continued imprint of policies of racial segregation and redlining on life chances today. And there are a number of other studies. There's a really great body of literature. I would recommend Paul Mohai and Robin Saha's Which Came First, People or Pollution, a review of theory, which looks at, some people might think, well, these are low-income areas, there are landfills, there are refineries, and so people with with less wealth might move to them. And they tried to answer that question, and what they found was that pollution moves to people of color and moves to low-income people more than the other way around. Of course, there's a little bit of both. And, in this country, all people should have the right to clean water, clean air, and a safe place for their children to play. That should be part of what we think of when we think of the environment and environmental law and the mission of agencies such as the Environmental Protection Agency. Just a note that when I was here before, next slide, we looked at what environmental justice looks like in Vermont. Is there an environmental justice in Vermont? And we're part of a coalitional effort called Rejoice, where groups came together and they held, and we were part of this, providing some legal assistance and support, held focus groups across the state and did a survey to ask communities, what does EJ look like to you? And found that there was something called EJ, environmental justice, in the state, and that having a co-productive relationship with communities where we heard from them helped to more fully inform our notion of what environmental justice was. But it's similar to the rest of the country in that it reflected environmental privilege and harms, even though Vermont is seen as such a green and environmental state, that there were these inequalities, disproportionate impacts, cumulative impacts, and the need and importance of engagement to really get at those issues. Next slide. So coming into the Biden administration, we had all that as background. I'll do a little bit more background, but I just want to remind us that in 2020, when the Biden administration came into office, we also had the reminder of these stark inequalities in seeing hospitalization and death rates from COVID were related to race and ethnicity. And there are lots of reasons for that, for the disparities, including workplace conditions. But studies during the pandemic indicated a relationship between PM10 levels and the dispersion of the virus and exposure to PM 2.5, which again, we already know is disproportionate in communities of color and low-income communities, and greater rates of hospitalization and death. And this study said, really was a wake-up call that this has these inequalities in the distribution of environmental benefits and burdens really have very significant impacts on morbidity and mortality. Next slide. So let me just touch on a couple milestones. We're going to play just a minute of this film, which is about what we think of as the growing consciousness in the early 1980s of environmental racism and the issues that we now call environmental justice. You can play the film for just a second.
We will not allow Warren County to become a dump site.
The State Highway Patrol began moving in on the marchers as they approached the entrance to the state landfill. The signs and chants of the protesters made clear their opposition to having the toxic chemical buried in their county.
Okay, you can yeah. So just that was a little clip which you can find online of the Warren County protests in 1982. There were PCB-laden dirt that was being moved into this landfill in a historic African-American community. And for 6 weeks, the community members, Native American, African-American, allies from local colleges, all came together to protest the movement of this PCB laden dirt into their community. They went to jail. They used tactics of the civil rights movement, but really focused in on the issues of what we now know as environmental justice. So there were tactics of the civil rights movement. There were forerunners in the Native American struggles for self-determination. There were forerunners in workers' rights like Cesar Chavez and the workers' movement around pesticides. But this particular movement in 1982 got a lot of TV attention, and it brought this local struggle to national attention. And in doing so, it woke people up across the country. That was quickly followed by the Toxic Waste and Race report in 1987, which made this connection, which was a study. Was it just happening here, or was it happening everywhere? Was there a disproportionality? They confirmed there was, again, which has been reconfirmed by a whole literature. The other interesting thing about toxic waste and race is there were a set of recommendations which were really prescient, or putting it another way, came out of the community and had an impact on policy. So they called for an executive order on environmental justice, which of course we know President Clinton signed Executive Order 12898, the first executive order on environmental justice. They called for the formation of an Office of Hazardous Waste and Racial and Ethnic Affairs, which subsequently became the Office of Environmental Justice. It was first called the Office of Environmental Equity, then the Office of Environmental Justice, and under Biden, it became the Office of Environmental Justice and External Civil Rights. They called for a National Advisory Council, which was called for in the Executive Order 12898 and became the National Environmental Justice Advisory Council, or the NEJAC. And other things. So this whole set of recommendations really came from communities, came from this initial study, and are a reflection of the fact that communities created the EJ movement, created the policy, and are not going to stop now. Keep going. Next slide. So I've already talked about Warren County, United Church of Christ. I just want to say that communities all across the country were experiencing these environmental injustices and saying, is it just us? This is Harlem. Just another example, in 2011, this is a fire at the sewage plant in Harlem. It's the origin story for We Act for Environmental Justice. There was sewage pouring into the Hudson. There's a long backstory to this, but folks in Harlem were saying, wait a sec, why is that sewage plant being put in an already overburden with very high asthma rates? And when the TV coverage happened in 1982, and then other folks were saying, well, wait a sec, we're experiencing that. There was a greater consciousness that it wasn't just their community that was experiencing these environmental problems, but there was a pattern. And of course, the scientific literature affirmed that. Next slide. So people came together in the first National People of Color Environmental Leadership Summit. Next slide. And that was part of the growing consciousness. And one of the things they did at this summit was pass principles of environmental justice. And these principles affirmed both substantive rights, like the right to clean air, the sacredness of Mother Earth, process rights, which I'll get to in a second, the distributional rights, and also ideas of restoration or restorative justice. Next slide. I just want to emphasize this procedural justice piece because it applies not only to the government, but to us as lawyers, or to me and the clinic that I run, or the clinic that we had here that folks here are running. That our work needs to be based on these principles of environmental justice, which call for self-determination, the right to participate as equal partners at every level of decision-making, including needs assessment, planning, implementation, enforcement, and evaluation, mutual respect. And these notions of procedural justice make their way into the executive orders and also state laws, state environmental justice laws, like the environmental justice law that we have here in Vermont. So just in sum, what is environmental justice? Next slide. It includes distributive justice, this idea of fairness in the distribution of environmental benefits like air, like trees, and burdens like pollution. It includes procedural justice, respect, equality, It includes substantive justice of equal access to clean air, clean water, outdoor recreation, healthy homes, health care, fresh food, and it includes restorative justice. If we're not in an equal playing field now, we need to restore legacy sites. Next slide. So this became enshrined in at the federal level, Executive Order 12898. And if you had, sort of, not to be sacrilegious, but if you had a Bible of the environmental justice movement, those principles of environmental justice might be on top. Then there's something called the Hemes principles. And then there might be Executive Order 12898 signed by President Clinton in 1994. There was no definition of environmental justice, but it called on every agency to make environmental justice part of its mission. And I will say that in the Biden administration, which I'm about to get to, the administrator made very clear that environmental justice or advancing justice was inherent to the mission of the Environmental Protection Agency, which you really can't protect the health and environment of people in the United States without protecting the health and environment of all people and taking account of issues of environmental justice. The presidential memorandum that accompanied Executive Order 12898 made clear that presidential powers were based on Title VI of the Civil Rights Act of 1964 and also NEPA, the National Environmental Policy Act. The president said environmental and civil rights statutes provide many opportunities to address environmental hazards in minority communities, a term we don't use anymore, but minority communities and low-income communities. Next slide. So as we were going into, I was here as the campaign was taking place, and then I got the call to join the Biden administration. And as we were preparing, all this was in mind, all of this, these values and principles. And Jill Lindsay Harrison wrote a book called From the Inside Out, which was a critique of EPA, that EPA was focused on the universal rather than the distributive aspects of pollution. That is, looking at, say, how much mercury is released across the nation. Is it going up or going down? And not what is the distribution of those releases? If you think about the Department of Education or HHS, Health and Human Services, they never release length of life data or 8th grade test scores without also releasing the distribution by race or by income or by region. So we can see if there are trends and if there are hot spots and whether we should address those trends. Are disparities going up? Or are they going down? What can we do about that? That had not been done by EPA. And so really starting to rethink that it's not, we have to be concerned not just about the global amount, the universal amount, but those disparities within the number. So an example of that is the toxics release inventory. It showed trends in mercury emissions, but not trends in who is exposed to mercury by race, national origin, or region. So the goals were to identify disparities where they exist and target investments or resources where they're needed most, and also to ensure meaningful participation. Next slide. Of course, we also had to take into account developments that really change how we think about environmental justice, including climate justice, which the climate justice movement grew out of the environmental justice movement. It too focused on disproportionate impacts of climate change on people who were vulnerable, such as people of color, low-income people, people with disabilities, and others. And often the disproportionate impacts of climate action. For example, a move to nuclear. Where's the waste? Where's the mining? How do we think about that? Or trading. And the need for communities to be at the table as we think through those options. Next slide. Another development that was pretty clear, although this is more recent, was just looking at who is most vulnerable, both to environmental pollution and climate change, and calling for the need to take issues of justice into account when planning for everything from emergency response to designing approaches to resilience and mitigation. And this is a picture from the wildfires out in California. And there was a New York Times story which really affected me. It was about a father and son that the father used a wheelchair and the son also used a wheelchair for different reasons or was in bed. And the father was calling for help to get out of the wildfire, and they were unable to get out before the fire killed them. These are the things that we need to plan for. They're in emergency response. And we now know that the intersection of race, income, disability can be particularly toxic. Next slide. So when Biden came to office, he called for a new executive order, or at least a study of whether we needed an executive order. And he committed to really dedicating ourselves to integrating environmental justice in all that we did. Executive Order 12898, signed by Bill Clinton, had called on every agency to make environmental justice part of its mission, which was an enormous step forward and the culmination of this effort by communities. But compliance by agencies was inconsistent. There had been a one-time planning session, but it hadn't been renewed. There was little accountability. While there was this presidential memo that recognized the role of civil rights and environmental law, it wasn't embedded in the executive order. And there was a need for an all-of-government approach. The Executive Order 12898 designated certain agencies that were covered by the executive order, but not all agencies. So that was part of coming into the administration, what was on folks' minds. And candidate Biden was really the first candidate to have a very robust platform on environmental justice. Next slide. Other things that had happened that really were platforms for moving forward is during the first Trump administration, states and localities had really moved forward in a whole new generation of environmental justice laws. Of course, there were already environmental laws at the state level. 16 plus states have little NEPAs. And there's a lot going on there. Every state has civil rights laws, so there was a lot to move forward with. And and I have on this slide, it could come later, but under the Obama administration, EPA had put forward something called Legal Tools to Advance Environmental Justice. We, during the Biden administration, worked on that, improved it, brought it up to date. But there was all this groundwork for the Biden administration. And I just want to give a nod to the fact that, next slide, Vermont itself had, in 2022, it wasn't before the Biden administration, but an act related to environmental justice, and it's still being implemented. There was sort of an iterative process between what was happening in the states and then what the administration did. Next slide. So then we get to the Biden administration, and I want to just say a few words about the gains in those 4 years between, from where we were when Biden took office to January 20th, 2025. So we're switching gears on how all this led to what was really unprecedented action in the Biden administration and those gains. So as a result of all this pressure from community activists and the growth of the Black Lives Matter movement, candidate Biden had this robust EJ platform. And through a series of executive orders, he immediately created an Office of Environmental Justice in the White House, established a White House, not just a National Environmental Justice Advisory Council, the WEJAC, the NEJAC continued at EPA, to make recommendations on advancing environmental justice. He established the Justice 40 initiative to ensure that resources were targeted where they were needed most. He required every agency to develop agency equity plans, and subsequently under the second executive order, which was signed April 21, 2023, established a government-wide definition of environmental justice, required every agency to develop environmental justice plans on a regular basis, and set forth a number of other charges to hold agencies accountable for integrating environmental justice into their work. So there was a lot happening every day on environmental justice, and we can talk more about all of these developments. Sometimes people ask me, well, was it a waste of time since it's all been deep sixed by the president? And I would say the answer to that is no. First of all, these documents, the definitions, they live on. You can deep six something, but we have it. We have those documents. We know what that definition was, and it's a more robust definition, and there'll be an iterative conversation with the next round of activities happening in the states and what happens in 2029. You can't erase history. You can try, but you can't erase history. And then, as the administrator would often say in our closing days, once you take a lead pipe out of the ground, you'll never put it back. So to the extent that, some of the resources, some of the investments, went into effect during the 4 years, such as taking lead pipes out of the ground in communities that are overburdened, or all communities, that will never be undone. That's a good, and that will save people, and it will save children, and that's a good thing. So yes, there's retrenchment, but there was so much that happened that's truly exciting. Next slide. One of those things was the definition of environmental justice. And again, Executive Order 14096 has been rescinded, but the definition lives on. And I underlined some of the areas that are new. And I will say in 2022, the Vermont's definition of environmental justice has a lot of these components as well. So there had been no federal-wide definition of environmental justice before this time. There had been one at EPA, and that was adopted by a lot of states. But this, and so some of the language here will be familiar because it builds on that language. But I should say that Executive Order 14096 came out of recommendations from the WEJAC, the White House Environmental Justice Advisory Council, and the Interagency Council within the federal government, building on a lot of what the states did. But so one of the things that really bubbled up is that environmental justice has to address issues of impacts that are particular and vulnerabilities that we were seeing coming out of COVID and as a result of climate change on tribes and people affiliated with tribes and people with disabilities. And so the WEJAC made that recommendation, the Interagency Council approved it, and the president's definition of environmental justice says environmental justice means the just treatment and meaningful involvement of all people, regardless of income, race, color, national origin. That would be familiar, but now also tribal affiliation or disability. The definition of who was covered, which agency was covered, was much broader. And then there's a lot of new language recognizing that we needed to take into account climate change, the cumulative impacts of environmental and other burdens, and the legacy of racism or other structural barriers. And not only focus on the maldistribution of burdens, but also equitable access to a healthy and sustainable and resilient environment. And again, you see a lot of these components in the Vermont law as well. Next slide. There was a lot of other activity. So there was activity at the White House level that applied to the whole federal government, but also activity within EPA. So the agency, I mean, I don't have time to discuss all that the agency did for sure, because literally every aspect of our work, our research, our science, our environmental enforcement, OECA, the Office of Environmental Enforcement and Compliance Assurance, put out 4 memos talking about the need to make sure that enforcement activities were targeting communities that needed it most. We put out legal tools to advance environmental justice, to really go through every statute and say, where is there a requirement or discretion? And that's still around. You can still use that to understand where is there discretion under the Clean Air Act, the Clean Water Act, the Safe Drinking Water Act, RCRA, the whole alphabet soup. Where is there a mandate or discretion? Now, getting ahead of myself, the president likes to slap words, adjectives onto phrases and pretend that it's true. So he says like illegal environmental justice. It's not clear what that means. Environmental justice is not illegal. And in fact, as he does that, we can use legal tools, which was a very precise, not comprehensive, but precise analysis of where we do have discretion or a mandate to consider environmental justice in statutes and regulations. And then there was an addendum on cumulative impacts. And so there's a lot of material out there to clarify legal authorities for addressing environmental justice. There was a lot of engagement, public engagement, to have input from all stakeholders, not only communities, but industry and states. Listening sessions, the administrator went on a journey to justice. Next slide, that there were practical impacts on the ground. And just to illustrate one, that when we came into office, there was a hunger strike. It had been going on for a few weeks. I arrived February 1, and it had been going on for a few weeks at that point. General Iron 2 was the largest metal shredder in that region of the country. The facility had been located in Chicago's predominantly white and affluent Lincoln Park neighborhood on the north side of Chicago, and there had been incidents there, and it faced a lot of opposition. After discussions with the city and the state, they decided to shut down and build a new facility in the southeast side of Chicago, in Lincoln Park, which was already very overburdened. And people saw this as a sign of environmental injustice or environmental racism, that this facility was in a white area, it was closing down and moving to an already overburdened Latino area. And yes, it had a bigger buffer over it. You know, the facility said it's going to be newer, it's going to be bigger, there'll be a bigger footprint, so it'll be further away from people. But there was a real concern about the impact in an already overburdened community. So people are on a hunger strike. In fact, some of the EPA staff were on a sympathetic hunger strike for a couple of days because they were really concerned about this. And the administrator didn't have authority to stop it, but he did take a look, and he talked to the mayor. He wrote a letter to the mayor on May 7th, 2021, and he suggested, after sort of reviewing the facts, next slide, that prior to reaching a decision on the merits, that the city complete an environmental justice analysis, such as a health impact assessment. And the mayor decided to do that. And on that basis, and also on the history of this facility, decided to deny the permit. That was challenged and upheld in court. EPA provided technical assistance on health impacts assessments through our Office of Research and Development and through Region 5. So it was just an example of the work to integrate environmental justice, equity, and civil rights into permitting, rulemaking, and the agency's many activities, both through our official power and also soft leverage. And the administrator stated over and over that baking environmental justice, equity, and civil rights into the DNA of the agency was the goal, in recognition that it was integral to our mission. Next slide. So I'd be remiss if I didn't mention a couple of other things that we did. The administrator launched the Office of Environmental Justice and External Civil Rights to lift this up, not have environmental justice sort of be off on its own, but to lift it up at the same level as the Office of Air and Radiation and the Office of Water, for example, to make clear that this was important. And this new office both had an unprecedented budget for environmental justice and civil rights, and also worked with all of the agency to integrate environmental justice in all that we did. Next slide. I'd be remiss if I didn't also mention the unprecedented levels of funding for disadvantaged communities. This is just the environmental justice and environmental climate justice money. Some were appropriations. The TIC-TACs, Thriving Communities Technical Assistance Centers, were an amazing program that Trump has recently been trying to defund, but to help communities navigate and have the capacity to get grants and navigate through what is a Byzantine system for getting funding for really important programs like, coastal restoration and solar. I know, here at Vermont Law and Graduate School, there's a lot of work on community solar, that kind of thing. That came out of appropriations. The environmental justice budget went from about 1 to 2 million historically to, through appropriations in the first year of the Biden administration, 100 million, and then to 3 billion with a B. But that was only a drop in the bucket of the amount of money that was going to disadvantaged communities under Inflation Reduction Act and bill. So this is just the environmental and climate justice money, but say air monitoring came out of the Office of Air and Radiation. And, there were all kinds of programs, lead programs, water programs that targeted resources to people that in communities that needed it most. Next slide. So there was a rollout of unprecedented funding. We strengthened civil rights in important ways, including issuing a procedural guidance, providing an unprecedented amount of technical assistance and training inside and outside of EPA, totally revising pre-award reviews so that if a community group or a state or agency was getting funding from EPA, any kind of funding, they had to have certain baseline requirements that were in our regulations, and we had increased transparency. We put our docket online, and it's still online, fortunately. And together with the Conflict Prevention and Resolution Center, we expanded the Civil Rights Program, expanded opportunities for community complainants to have a voice in resolving their complaints. There was a NEJAC working group on making recommendations, just a tremendous amount of work. It was maybe baby steps. It wasn't where we needed to go to really make up for decades of inaction, but it was, they were important steps. We put out new materials, new guidance. EJ Screen, as an example, had covered the territories like the Virgin Islands. There was a new index that was really important that could be used for guiding grants. And I think the next slide is on disparities indicators. So let's go to the next slide. Yeah, this is one of my favorite things that we did. Remember, I talked about Jill Lindsay Harrison's book and how TRI and other data that we put out was usually only universal and didn't really dig into disparities. Well, for the first time, we were trying to change the conversation and put out an initial batch of indicators of environmental disparities that aim to help illustrate disparities in key environmental and public health conditions. The pilot 6 indicators were blood lead levels, populations in monitored counties meeting PM 2.5 national ambient air quality standards, hypertension, adverse birth outcomes, life expectancy. But all of this could then feed back in understanding where do we need to target our work. Next slide. So that leads to the challenges. And I want to talk briefly about challenges pre-Trump and then the challenges of Trump and then a little bit of what we're doing. So I have a few more minutes, but first I want to say there were challenges even before this administration came into office. Even today, the Supreme Court ruled in 7 counties. I haven't read the whole decision, so don't ask me detailed questions about it. But a NEPA case with a decision by Justice Kavanaugh that NEPA is a procedural cross-check, he said, not a substantive roadblock. And they overturned the DC Circuit, which had said that this project needed to look at upstream and downstream effects. So we have a court that has moved in a certain direction, and that's already the landscape we're facing. And that landscape also includes a skepticism about race-conscious action, which provides a legal landscape for work that we're doing in civil rights enforcement and addressing racial disparities. And we have to be thoughtful and work within the law to address those racial disparities. Doesn't mean that addressing racial disparities is illegal, but taking race-conscious action raises constitutional concerns, at least for the government. And there was pushback on our civil rights enforcement. It wasn't only the courts, there was also sort of an organized pushback. And at EPA, we were sued by the state of Louisiana in a pretty high-profile case, Louisiana versus EPA. This was a case that involved complaints we had received and were investigating about 2 facilities in what's called Cancer Alley, very overburdened communities. And we were investigating, and the law requires that we have a back and forth and try to resolve cases voluntarily. And Louisiana's Attorney General, now governor, sued us, saying that the case raised concerns and found a judge, Judge Kane, in the Western District of Louisiana that permanently enjoined us from enforcing the disparate impact standard or the regulations that prohibit actions with an unjustified disparate impact and cumulative impacts analysis under Title VI. Happy to talk more about that. Okay, so that's the sort of lay of land until January 20th, 2025. Next slide. We then get to January 20th, 2025. And from day one, the president shows hostility toward efforts to address racial inequality. He bundles DEIA, which he says, uses disparagingly, and environmental justice. They're very different, but he bundles them together because, I guess, they're all trying to address some form of racial inequality. They're not only doing that, they're also trying to ensure meaningful involvement. They're trying to ensure, in the case of environmental justice, clean air, clean water for all. In the case of DEIA, there are also universal goals of inclusion, but he bundles them together in this disparaging way. And, you know, the title of that first day one executive order is Ending Radical and Wasteful Government DEI Programs and Preferencing. And this includes language about equity action plans and equity and environmental justice. Somehow through the title, he's trying to suggest that advancing equity or environmental justice is a form of preferencing, ignoring the history of discrimination in land use and stating as if true that somehow prioritizing communities in greatest need is a form of preferencing. The EO calls for the termination of environmental justice offices and positions. Fairly immediately, the Department of Justice's Office of Environmental Justice and other EJ offices across the federal government are closed. And fairly immediately, hardworking civil servants in the Office of Environmental Justice and External Civil Rights were put on administrative leave. And it became clear through rumor that they were going to reorganize and get rid of the office. And now we know that they're all going to be riffed, that they're all going to be fired or moved. I just want to say this is a huge loss for the federal government. Many of we had not only staff at headquarters, but there were parallel divisions in the regions. Many of those division directors who were put on administrative leave and now either moved or fired spent decades building trust in the federal government with communities, low-income communities, tribes, and others who had long distrusted the government, and these relationships were invaluable. It's also worth noting the somewhat Orwellian provision of this executive order requiring agencies to provide the director of the Office of Management and Budget with a list of all DEIA or EJ positions that have, quote, misleadingly relabeled in an attempt to preserve their functions. So this idea that we're sort of going to rat on each other. Next slide. Other early actions. I mean, some of this, you know, there are a whole bunch of executive orders. They eventually repeal Executive Order 12898 signed by Clinton. They repeal the Executive Order 14096. That gets rid of the NEJAC, the WEJAC, the Interagency Council, all of these efforts. The Department of Justice is also just ravaged. Their Civil Rights Office is ravaged, and we know even a lot more now. Next slide. We also have the freezing and termination and uncertainty of environmental and climate justice funding. In a video posted on X, the new way of governing, apparently, Administrator Lee Zeldin said that EPA would revoke contracts for the still emerging at that time Green Bank that was set to fund tens of thousands of projects. People had worked hard on these projects. Next slide. I just wanted to show the grist.org slide of where the grants are. You'll note that these are bill and IRA grants, a bipartisan infrastructure law and Inflation Reduction Act. They're everywhere. They're in red states, they're blue states. They weren't given to, they were all done, they were done through competitive processes where there were applications and they were scored. And, they are really incredible projects that people put time into. Next slide. There's so much more. This is a complete wrecking ball. And next slide, I want to highlight the removal of data and information. Some of this is back. They removed EJ Screen. They removed HHS's EJ Index, Health and Human Services EJ Index, but in a snarky way. So this is what I saw when I went to EJ Index homepage. They note that HHS is required to restore their website, but they disagree with the data that's in there based on their ideological position. So by court order, that was restored. There are other court cases trying to get more information restored. Next slide. But there is an attack on data collection that we need to pay attention to. There's a census case that's from 1976 where New Hampshire filed had stopped filing EEO, equal employment reports, and challenged the census, said it was illegal to collect racial data and publish it. And the courts upheld that as collecting census data, demographic data, as a legitimate government function. But this year, there's a case, American Alliance for Equal Rights versus Bennett, which is a challenge to the state of Illinois' requirement that certain nonprofits collect and disclose demographic data, which, by the way, is required under many regulations by many agencies. But Attorney General Pamela Bondi intervened in that lawsuit successfully on the side of saying that it is illegal to collect and to require collection and posting of that data. Next slide. There is also this attack on disparate impact, the disparate impact standard. Happy to talk more about that. There was an executive order called Restoring Equality of Opportunity and Meritocracy, which really is just retrenching on the strength of civil rights law. It's part of a very long effort to roll back civil rights law. And now we're seeing, pursuant to that executive order, agencies, they're not actually promulgating new regulations. They're trying to bypass the APA, and the Department of Energy released a direct final rule, which is bypassing the APA, and comments are due on that direct final rule to rescind the disparate impact regulations and other regulations on June 16th. And again, happy to talk more about that. Next slide. So where do we go from here? I've already talked about commenting on rules and ways in which courts have already stopped the administration from doing some things. Just want to say a few words about the rule of law, states and localities, and what they're doing, and communities. We're going to have to see how Trump's efforts play out in court. I've lost count. There are hundreds of lawsuits that have been filed against the administration, and judges have issued multiple orders blocking actions. Next slide to say a little bit more about that. This is just a few of the suits that push back on the actions I've talked about: litigation to challenge the freezing and termination of grants, personnel actions, and some of us are involved in trying to also organize community defense, EJ clinics, community and economic development clinics, pro bono assistance, groups like Lawyers for Good Government, Environmental Protection Network, providing an array of services from public education so they know if they fit into, say, an injunction, or what their rights are, to counseling, to representations, to being part of litigation. And Lawyers for Good Government has an intake system if you know a group that should plug into that. And there's a role, a really important role, for litigators and for attorneys general. So we're going to see what happens, whether the rule of law holds, but there's a really important work going on there. Next slide. States and localities play a really important role, both in pushing back on illegal activities by the federal government and also by continuing to push for environmental justice. Almost every state, I think if you go to the mapping tool that the EJ Clinic here has helped develop, I think there may be 6 states that don't have something that might be called an environmental justice law, but most states have some kind of law, regulations, or process, including mapping tools, advisory committees, language access laws or rules, public participation policies, cumulative impacts laws, enforcement of civil rights laws. So that needs to continue, and that will be our bulwark. Even red states and other states, all across this country have some states that can be enforced, little NEPAs, all kinds of laws. Next slide. And of course, I started with this, and I'm going to end with this, that communities are at the forefront of continuing to push. They were at the beginning. That is the strength of the environmental justice movement, and they're going to keep going. Next slide. So the last thing I want to say is we can get discouraged, but I've been thinking back to the beginning of my practice, which was during the Reagan and Bush 1 years. And I went to the NAACP Legal Defense Fund, and this is Julius Chambers, who was the director counsel of the Legal Defense Fund. And we went on a retreat to talk about how we survived the Reagan-Bush years and how we strategize around it. And of course, at that time, it seemed like a nightmare because the Reagan administration was moving the Department of Justice from pushing for racial equality to intervening in or switching sides on school desegregation cases and affirmative action and so much more. And it felt like a real retrenchment. So we were all sitting around in a room in a beautiful place and on this retreat, and everybody was like, what do we do? What's our strategy? And Julius, who was just amazing, he argued that Swan case. He argued Griggs, which established disparate impact under employment discrimination. And we all looked up to him, but he was Socratic. And so he said, listen to yourself. And we're like, okay, we are. And he said, eventually we pulled it out of him that what he was saying was he grew up in segregation. We got to get a grip. Things have been really bad in this country and people have lived through really bad times. And we have to pull ourselves together. And as Thurgood Marshall did, as Charles Hamilton Houston did, we have to find our strategies and work toward a better future. And so bending the arc of the law toward justice is why I went to law school, and I continue to believe in this goal. Okay, I hope we have a few minutes left for some Q&A.
Thank you, Marianne. And yes, we do have a couple minutes to address some questions. And I know that Brian here in IT is working on making sure we can see everything and in the right way. But I have a few questions from a former colleague of both of ours. Former Dean Jenny Rushlow is joining us from her current post at Conservation Law Foundation, where she is gathered with several CLFers in the conference room in Montpelier. She had a few questions. I'll just maybe a bit of a lightning round, and let's see. Okay, great. Was the Office of Civil Rights at EPA able to work through its backlog during the Biden administration? And well, maybe an update on that.
This is a lightning round?
Yeah.
Okay, the answer is yes.
Yes, very short, very short. Yes.
The slightly longer issue, and great to hear from you, Jenny. There was really no backlog. During Trump 1, there was an effort called lean management to be more efficient. And we may not like the way in which they disposed of cases, but they really worked through the backlog before we came into office. And I don't know if I want to give them credit for that, but there was no backlog. I will say I learned a lot about civil rights, the processing of civil rights cases. And it takes, if you take a case, it probably usually, if you do your job well, takes more than 180 days. So did we, during the Biden administration, when we were really digging in, did we always abide by the 180-day deadline? Technically, we worked really hard. We worked with diligence. But there were cases, and all of the cases, the whole docket is online, so you can sort of track that. There was no case, and when I brought that unreasonable delay suit, there was a case that was like 3 decades old. And I represented 5 groups, each of whom had a case that had been accepted for investigation more than a decade before. There was no case like that. But were there cases that it took us more than 180 days in good faith to do a good job in investigating? Yeah.
One other question that comes up and is sort of localizing things to Vermont. As you noted, sort of under the EJ law, we're in the process of developing an EJ mapping tool for the state. And is there anything you learned through the EJ screen work that you did about, lessons learned that we could apply here in Vermont or other states? Other states have similar initiatives, as you referenced, our EJ state by state database that our Environmental Justice Clinic worked on here is still available and still still being updated. So those efforts are going on around the country, and I'm wondering if you have any thoughts on the sort of mapping strategy, lessons learned.
Yeah, absolutely. And we could have spent the whole hour on mapping strategy because there's a lot of experience now. It started with EJ Screen at EPA. And then Cal EnviroScreen has a really robust program. And then many states, like 22 states, got money from the tracker systems that HHS seeds funds for. Washington State was one of the first to take that tracker, which is health tracking, and turn it into a community mapping tool. And then when there were a number of states that were developing, Maryland and others developing tools. Then we came in and the White House created CGEST. The HHS created the Cumulative Impacts Index, and we created the supplemental index to EJ Screen and made it more robust. So there's a lot that's happening, and absolutely. So one thing is, what are you using it for? Depending on what you're using it for, there might be legal constraints on what data to include. You may or may not want an index. There are different ways to develop an index. different states have different priorities. One thing that Washington did that was really impressive and very helpful is they got some funding. The university, the government, and a community group, front and centered, came together and did, I think, 11 focus groups around the state to ask what are the key indicators of environmental justice or vulnerabilities. Like, it matters whether your shoreline, maybe flooding is important in your state, maybe it's not. Or maybe even if you're not shoreline, like Vermont, you have a lot of rivers and you have storms, and it is important, right? Do you have an indicator? And then having these standards of like, do we have statewide indicators that are sufficiently granular? I'll get back to that in a second, that are accurate, sufficiently accurate that we can include them. And what front and centered, and Cal Bioscreen has done this too, is they have 1.0 with the data they can use, and then 2.0 as they build more indicators and they can improve it. So there's a lot of great experience. And the other thing I was going to say, another lesson that I think is really important, is your level of granularity is really important. One thing that EJ Screen had is we went down to the community block group level. And so census tract is a pretty big space, and it masks disparities within a census tract. So that to the extent you can get down to the census block group level, that is more helpful in addressing issues of environmental justice. Anyway, there's a lot to be said about this. I'm super glad that Vermont is moving forward with this. It's really important, and it has ramifications, legal ramifications and policy ramifications that are important and important to communities.
Thank you, Marianne. I think we're out of time for our talk today. We could talk about this, as you say, for a whole day, a whole class. There are opportunities here to do that in the summer with some of our courses, but we are so grateful for your presentation today. Thank you for joining us. And thanks to everyone who joined online. Our next talk will take place online on Tuesday next week. In terms of coming attractions, if you've been captivated by this topic, which is so important to all of us here at VLGS, we'll be talking more about it with Professor Sharmila Murthy from Northeastern coming up later in the series. So thanks everyone for joining us, and have a great day, everybody.
Thank you. And I'm happy to follow up with anyone who wants to reach out to me. Take care.